So you have been dragged into a small claims matter, or perhaps you are dragging someone else into small claims court. What are you likely going to experience? We're going to talk about that in today's video. 4 things you can expect in small claims. Stick around. Out there, welcome back to Wedding Industry Law. My name is Rob. I am a wedding industry lawyer, and in today's video we're talking about 4 things that you might expect in your local small claims court. So what is small claims court? Small claims court is going to differ from jurisdiction to jurisdiction, but typically it's going to be a court that hears consumer claims for a certain or up to a certain amount of money. So if person A is suing person B for breach of contract or for money that falls under the jurisdictional limit, and jurisdictional limits it just depends on what state you're in, what county you're in. I've seen them for $5,000. I've seen them go all the way up to $25,000. And why somebody thinks $25,000 is a small claim, I don't know. $25,000 is a lot of money to me. But anyway, so I guess that being said, a small claims court is typically not going to be a court for complex things. You're not going to get typically injunctive relief. For example, injunctive relief meaning an order from the court for somebody to do something or not do something. It's typically just going to be for the purposes of, an award of money damages for simple claims, typically consumer claims. In other words, it's going to be for simple things, small claims, right? I guess that's where they get the name from. So the first thing that you can really expect if you're dragged into small claims court is that the atmosphere is typically not your typical court experience. Most of the parties in small claims court are not represented by attorneys. They're individuals that have probably never been in court before. And, for lack of a better word, it's crazy town. It can be a madhouse. People don't know where to sit. People don't know how to act. People don't know how to behave. So don't expect to go in and it look like LA Law, or if you're not 50 years old, it's not going to look like, Suits. What's the most recent? Boston Legal? I don't know. I'm an old man. It's not going to have a lot of, of the normal decorum that you would see in a typical court. For example, like, you're going to go in there and it might take 2 hours for them to go through the docket because just people aren't used to that. And because when there's no lawyers to stand up and make it flow more, quickly or with more fluidity, you just get a lot of chaos. So at the end of the day, chaos is what you're looking at most likely in small claims court. Number 2, typically the normal rules of evidence are typically more relaxed in small claims court. And that's because small claims court is typically for people making their own claims without a lawyer. So naturally, the judges who are the fact finders typically in small claims court are not going to be, hard asses about whether or not your document is hearsay or not. The rules of evidence are more laxed. What the court typically in most jurisdictions, we are trying to incentivize and promoting people to come in, just bring your documents, bring yourself, bring your argument, tell us what happened, and we'll let you know whether or not you can, you're going to get a recovery or not. And so for that reason, you're not going to have a law degree to understand whether or not, what you have is actually evidence that can be admitted or not. Now, that's not to say, I've been in situations where the small claims court judges will in fact, I'm not going to hear that. I'm not going to do this. You need to come back with this X, Y, and Z. That does happen. But for the most part, it's a relaxed atmosphere as it comes to evidence and the judge hearing evidence. Now, third thing to expect is that because you're in small claims court, because the evidence is relaxed, because you likely are not dealing with somebody that has an attorney, the normal civil process rules, and when I mean civil process, I mean discovery, like subpoenaing people, making witnesses appear through subpoena power, requesting documents. Typically, these are relaxed or non-existent. So in other words, there are many small claims courts that are not going to allow you or not going to help you request documents from another party or from a third party. They're not going to allow you to subpoena people. Now, just some, not every jurisdiction is like that, but a lot of small claims courts are from that standpoint. You are going to have to come to court and plead your case and present your own evidence and present your own documents. The small claims court process is typically not going to allow you to subpoena records from third parties. It's not going to allow you to subpoena witnesses to show up. That's typically reserved for courts of general jurisdiction that are not small claims court. So if your particular case is going to rely on third-party witnesses, then your hope is that you tell them to show up and they show up, because there's not going to be a judicial enforcement of them showing up. Okay. And the reason why is because, again, a small claim is they're expecting you to come forward and out of your own mouth present the evidence, out of your own mouth present the testimony that you need to win your case. If your case revolves around, somebody in another county, someone else bringing some particular recording that you need and they're not friendly to you, small claims might not be the court for you, because there's not a mechanism typically not a mechanism to force these people to bring the evidence that you need to present and win your case. You are responsible for bringing your own evidence. So you need to do a lot of research on that. Make sure that if it's not just you telling your story and you need something else, make sure that your small claims court allows you to do that. And if it's not, small claims court might not be for you. The fourth thing to consider, or fourth thing to expect with small claims court, is that often, very, very often, dispute resolution and mediation and trying to resolve through settlement is almost always required. And that's almost always required in the form of everybody that's here, you are required to step outside, talk to the other party, and try to resolve the situation outside of the courtroom in the hallway. That's one way. Other ways in which the court requires you to resolve your dispute is through mediation. So they might say, hey, listen, for the next 2 hours, we have, mediators A through Z standing out there, and they're willing to mediate the dispute with you. And if you can come to a resolution, you can. And if you can't, come back in and we'll hear the case. So almost always, the small claims court is going to try to get you to resolve your dispute through negotiated settlement or mediation prior to you actually stepping in front of that judge and pleading your case. And, that's often effective at getting rid of at least 30, 40, 50% of the cases on the docket, because, a lot of times party A has not talked to party B. And once they talk, they're like, you're not such a bad guy yourself. I just wanted $50. And so, the case gets resolved that way. You step back into court and the judge writes it down. Party A has agreed to accept $50 in full and final settlement. By order of the court, boom, you're done. So just because you're in small claims court doesn't necessarily mean the judge is going to hear it. The judge is going to force you to try to resolve it. And oftentimes it does get resolved. So at the end of the day, 4 things to expect. Number 1, small claims court can be pretty crazy town. Number 2, traditional rules of evidence are relaxed. So, again, you want to research this, but typically it's not so much about, whether or not this document is hearsay or the document is accurate or whatever. It goes really to the credibility of the testimony of the parties themselves. Number three, the civil process behind, discovery and motions and things like that are typically super relaxed or non-existent, to the extent that you probably are not going to be able to file any motions. You're probably not going to be able to issue any subpoenas or requests for productions of documents. So if you need documents, if you need evidence, if you need things to be done through motion, it's probably not going to happen in small claims court. And number four, finally, expect that the judge is going to require that you try to work out your differences with the other side. And that is four things to expect in pretty much most, if not all, small claims courts across the country. If you found this video helpful, please be sure to like and subscribe. If you've ever been to small claims court in one way or another, please let me know. Leave a comment down below. Let's get a conversation started about it. Small claims court, what do you know? New videos just like this out every week. In fact, next week, we're going to be talking more about small claims court and how to win your case in small claims court. Anyway, new claim, new claims, new small claims courts, no, new videos every week. And with that, folks, we'll see you next time.